This is Charlton Zoning Board of Appeals, continuation of Hilka Construction Appeal, October 17th, 2017. So from the end of the last meeting, we were going to hear the zoning enforcement officer wanted to present some information to the board, and then we'll hear from Hilka Construction, and at that point we'll probably close our hearing portion and begin deliberation on a vote.
Mr. Chairman?
Yeah.
Can I just clarify that under the presentation of evidence?
Rebuttal by objectors? How are you the objector?
We're the ones that filed complaints.
This is the way I'm gonna do it. So, we spent an entire meeting. We've heard from, we're gonna hear from the zoning enforcement officer, and we'll let Hilka speak. I don't know what other information that you guys can offer. I mean, if there's something that's pertinent to the zone, specific zoning issue, then maybe we'll see, but that's the way this is the way I do it. I said I was gonna do it last time, that's the way we're gonna do it. All right, Mr. Meskis?
Mr. Chairman, members of the Zoning Board of Appeals, the Town of Charlton, through the zoning enforcement officer, is not trying to close the Hilka operation down. The Town of Charlton and its officials are charged with protecting the rights of its residents and answering their complaints and concerns, balanced with the rights of the pre-existing business to operate with the proper oversights and any permits. When written complaints started coming to my office, I knew this was going to be a serious issue. Based on complaints, I offered to John Hilka to meet with me in an email dated June 27th. His reply included bringing his lawyer, which is shown in pages 6 through 10 of this package I gave you. Since I did not have access to legal counsel for the meeting, I had to withdraw the offer, which resulted in my June 28th letter that has been provided. Then there was an email string where I offered to meet, which was followed up by an email from John stating they would come and ask some questions, and then an email saying that the Hilkas decided not to meet with me. Those are attachment A. The appellant's attorney has pointed to the zoning enforcement officer's dependence upon Rock Engineering Machinery Company article. I call your attention to paragraph 5 of that article, which states in 1984, when the first stationary crushing plant installed at Hilka had a capacity of 500 tons a day. Quote, "Through the years," John said, "there have been many changes and upgrades with an eye towards increasing production. A major upgrade of our washer and classification equipment was completed in 2006 with eye towards quality control as well as production," end quote. Marked attachment B, that would be page 4. This is a direct quote attributed to Mr. Hilka in this article. The board is not bound by the rules of evidence, and it is important to note that the appellant has offered no documents to refute these statements, claiming they have no records of past or current production levels. Whether or not, as the article goes on to say, the production has increased to 2,500 or 3,000 tons a day has not been refuted by any documents presented by the appellant. I would suggest that sales records, while not directly correlating to production, would be an indication of the amount of product produced. You cannot sell what you don't make. Further, to invest capital money to upgrade the capacity production potentially sixfold and not use that capacity to make a return on investment does not make common sense. While the appellant wants to discredit the information provided by the zoning enforcement officer, they have introduced photos purporting to be work areas that are undated and without verifiable locations. Further, the photos reported to be pre-1987 marked Hilka 1 and 2, pages 12 through 17. There appears to be a considerable layer of loose dirt above the rock layer with mature trees growing on top of that. That standard deciduous trees in the background, see Hilka 3 and 4, shows what appears to be mature hardwood trees uniform all the way through the background. On October 3rd, 2017, aerial photos from 1985 were introduced which show the thinning of vegetation on the north end of the excavated area. I suggest that this is the area represented by the photos mentioned. That was the photo produced by Mr. Doyle at the last meeting. Now turning to page 14 through 16, the Google Earth images labeled Hilka 3, 1995, 4, 2001, 12, 2001. We can see the footprint of the land clearing and mining activity had not changed considerably until sometime after December 2001 and before August of 2003, with mature deciduous trees covering the perimeter of the cleared area. If there had been tree clearing activity in the mid-1980s, as claimed by the letter dated September 13th from Paul Hoodback, of Hull Forest Products, why is this canopy of forest consistent from the subject property to the adjoining land? I would suggest you look at the remaining images provided. If there had been tree cutting and mining of loose materials in these areas of operation, why is there dirt with trees growing on it? Even if the board believes the claim that the upper area of the site was cleared of trees prior to the enactment of zoning, they cannot deny, as the pictures demonstrate, that this area subsequently became reforested. This obviously could not have happened if the topsoil had been removed and the area mined. Therefore, it is my suggestion that grandfathered use does not extend for this portion of the site. Further, we have no documented evidence of the extent of land clearing or mining between 1985 and 1995. We do, though, have aerial photos which show between 1995 and 2001 there was a slight increase. However, it is also clearly evident that between December 2001 and August of 2003, there has been an increase that I suggest is substantial in nature, into areas not previously cleared, mined, or explored. The appellant has provided information that the number of employees working for the Hilka companies has not increased significantly over time, which may be true. But where are the records to support this, and what about subcontractors? I call your attention to the upper portions of the Google Earth image labeled Hilka 4 2016, showing the second crushing and screening plant on the property. The zoning enforcement officer is not the decision maker for Massachusetts General Law, Chapter 48, Section 6 finding. That responsibility is assigned to you, the Zoning Board of Appeals. I would note, however, the fact that so many neighbors are complaining about the operation now, if they had not before, suggests that the impact of the business on the residences, particularly noise and vibration, have intensified. The logical conclusion is due to the fact that the operations are now much closer to the residents than was previously the case. Finally, I would ask the board to hear from Special Counsel Jonathan Silverstein.
Go ahead, Counsel.
Thank you, Mr. Chair. Okay, my name is Jonathan Silverstein. I'm with the law firm of KP Law. We're a municipal law firm, and we serve as special counsel to the town. I've been asked to work with the town with respect to this matter. During the first hearing session, a little bit during the second hearing session, there was a lot made of the notion that Mr. Meskis was trying to shut this business down. I think a reading of the order shows that's not the case. The facts show that's not the case. They've been operating since issuance of the order, operating under an agreement by Mr. Meskis that they could operate within the 1995 footprint of the operation. So I think that's really just a smokescreen. The notion that the town's trying to put out of business this multi-generational business that's been good for the town has no relationship to reality. It's just not true. What was the purpose of the order? The purpose of the order is that Mr. Meskis has had many complaints from abutters telling him that the impacts on residential neighborhoods of this operation have been increasing over the years, dramatically in the last couple of years. And what's the purpose of zoning? The purpose of zoning, the primary purpose of zoning is to protect sensitive land uses like residences from more impactful land uses like mining operations and sand and gravel operations and other industrial uses. And I think, when people talk about, well, these residents moved into the area knowing there was a gravel operation, I think you have to bear in mind that town meeting voted to draw those lines. And the lines they drew was to make this a primarily residential zone, not a primarily industrial zone. So you can't fault people for moving into a residential zone and relying on the existing state of a non-conforming industrial use that at the time they moved in may not have been impacting. And when you look at the powers test that was discussed by the applicant's counsel at length, and I agree with what they said about what the powers test is, the primary purpose of the powers test is to make sure that non-conforming uses can remain, they can change with the times, but when they start to impact residents in a way that is different from what predated zoning, that is more severe than what predated zoning, that's when they need to come to this board and get a special permit. Mr. Meskis doesn't have the authority to say, sure, why don't you expand the footprint of your operation? That's not his role. This board can do that. And when we talk about trying to shut the business down, I think it's important to note that we implored Hilka to seek the special permit. We said, look, you can have a contemporaneous hearing. Come in. We're not looking for you to waive your rights to dispute the cease and desist.
When was this conversation taking place?
It was prior to the appeal being filed with this board. When was it, Kevin? It was
after the appeal.
before the hearing, well before the hearing.
Before the hearing, but after the appeal.
And certainly in plenty of time for an application to be filed and for the hearing to be held on the same night. It was my first conversation with Mr. Polanski, which was shortly after the cease and desist order was issued.
So it was after the fact then?
After the cease and desist order,
Correct.
but before this hearing, they easily could have sought the special permit at the same time, which was my suggestion. Look, I'm not looking for you to waive your rights to appeal the order. Just ask for the special permit. And Mr. John Lane, at the last hearing session, he got up and spoke to the board. He spoke very articulately of John S. Lane and Son Quarry. And he said, I've been in this room before. And it's true. I was in that room with him in West Stockbridge. And after he probably spent $250,000 in legal fees, you know what he finally ended up doing? What we had told him to do in the first place. Sit down, reach a settlement, work with the neighbors, try to come up with something that is reasonable. Because if you take Mr. Polanski's argument to its logical conclusion, there's no limit on where they can quarry on the property, as long as they don't produce a whole lot more in any given year. So they can blast right up to the property line. And that doesn't make any sense. And that's not what Powers suggests. And that's not, frankly, what the purpose of zoning is, and it's not what these residents deserve. The proper place for that sort of thing to get worked out is before this board come up with a reasonable solution of a way to protect the residents, allow the property owner to make a go of their business, but with some protections in place. They have the right to pursue this appeal. And John S. Lane pursued its appeal, and I sat through weeks and weeks of deposition of him, of the neighbors, of his engineers, and at the end of the day, he did exactly what it was that the board was looking for him to do in the first place. I don't think that is an approach that makes a lot of sense here. So let's talk about what an expansion is with respect to the Powers test.
What is the Powers test now?
Okay.
That does, I don't know.
Mr. Kalinsky and his colleague refer to what's known as the Powers chocolate test, which is named after two cases issued by the Massachusetts courts that set forth a three-part test for when someone is expanding a pre-existing non-conforming.
The grandfather clause.
That's right. And at what point that
It goes over the line.
it goes over the line. Okay.
All right.
And so really what we're, the first two parts of that test, the course just sort of merge into one generally. And really what you're getting at is, has the character and nature and intensity of the business changed? Number one. Number two, has its impact on the neighborhood changed? Now, people keep saying, well, the ZBA deals with zoning, not with blasting. That's true in a sense, but it's not true in a sense. The ZBA doesn't administer the state blasting regulations. That's true. And Mr. Meskis has never argued, I'm not aware of any of the residents arguing that the applicant has violated any of the blasting regulations. But that's not the issue before this board. The issue before this board is, how are the residents being impacted, and is that the same as the way that those residents were impacted in 1988, in 1990, in 1995? And the answer, according to the residents, is no. And you have to decide, do you believe them or not? Do you find their testimony credible or not? That's for this board to decide. But I think it's reasonable to assume that if blasting gets a lot closer to you, and as Mr. Meskis just told you, there was overburden on that entire upper area that's now being quarried.
Overburden is what?
Overburden, according to the applicant, is the top layer of soils, loose material before you start blasting. So you have to remove all of that overburden. First you remove the vegetation, then you remove the overburden.
Are you suggesting they should have removed all that area in 1995?
I'm not suggesting they should have done anything. What I'm suggesting is that that area was not being quarried.
Yeah.
That area was not being quarried in 1988. And so, in order for them to expand into that area and bring with it the increased impacts to the neighbors.
How does that balance with the Powers test?
Well, the Powers test tells this board to look at the way in which the current operation is impacting residential neighbors, and whether that's the same as the way it was impacting residential neighbors prior to zoning in 1987. So clearly, if you blast a lot closer to someone, even if you're complying with blasting, with the state blasting regulations, you're going to be impacting them more. And that's what you're hearing from the neighbors. You're going to hear the crusher more. You're going to get more dust, which, again, you've been hearing about from neighbors.
Yeah.
All of those impacts, when you move the operation substantially closer to residential neighbors.
But you're talking about 40 years. They use up one portion of their territory and then go to another area.
Well,
We're talking over 40 years.
yeah, so I'll submit to you, number one, there's been no testimony that they've used out the historic area, and they've been working within the 1995 footprint during the cease and
You
desist.
blast rock, does more rock appear? Well, then how would you use that
Have you heard
area?
testimony, sir, that
Well,
all
I'm
of
just-
that,
That's,
that the
that's
whole area
logic.
would?
That's logic.
Well, I was trying to answer the question he asked. And I know he's your client in another matter, so that's all right, but,
Is that a matter that you and I are handling? Let's leave that alone.
well,
Is that not a conflict of interest
Yeah.
for him sitting on the board?
Who are you talking about?
You.
Who represents me?
Yeah, who represents him?
my
Nobody
understanding-
represents me here.
Fair
I
enough.
represent myself, so
And I
where,
take
what are you
offense
talking
to
about?
that comment.
Exactly, where's
Fair
that
enough.
from, sir?
I
Let's
retract the
let's
comment.
keep,
Well,
let's keep it civil.
You're counsel
We're trying
here,
to
and you're
figure out
accusing me
whether
of
or not
something?
we're gonna uphold the cease and desist.
Sir, I'm trying to
You
answer
don't
a
know
question,
me.
and you're
Rob,
cutting me off.
Okay,
Rob.
that's ridiculous.
Rob, keep it,
That's-
everyone, let's keep it civil.
Fair
Well,
enough.
our position here is to figure out whether or not we're gonna uphold or we're gonna overturn the cease and desist order. So if council is gonna give us information that's gonna help us make that decision, then let's just do it that way.
Well, it just, the statement didn't make sense to me, and that was the purpose of me
Well, if I could answer
reiterating
it,
it.
I'd love to answer the question.
So that's all.
You have not heard any testimony that they have blasted all of the rock out of the 1995 boundaries, and to the contrary, they've been blasting within the 1995 boundaries since the cease and desist order. So I think that demonstrates that there's plenty of rock still there.
Why isn't the 1995 boundary that crucial?
So when I did my research on this, the first available image was a 1995 image of Mass GIS through Google Earth. I did not have access to anything prior to 1995. So that's what we used as the footprint.
But isn't the sand and gravel operation, you go to one section, you use up that section, and then you go to another section. Over 40 years, things are going to get denuded. The overburden is going to be stripped.
You can continue to mine downwards within that 1995 area, and then I would say it's not an expansion. Right? They haven't increased the area.
But increasing the area in itself for both, this is for both of you, increasing the area doesn't necessarily mean that you violated the first two prongs of that powers test, though, does it? I mean, if we're
In
gonna
and
talk
of
the
itself,
impact,
not
the impact is
necessarily.
the impact is a different story.
That's right.
Right, so they could be expanding their area, in terms of how much, where they're taking the soil off, either it's the overburden or blasting, but not necessarily cause an impact that's different than from 85 or 87 upon the neighborhood.
That's a potential if they were expanding in a different direction. It's all for this board to determine,
Right.
right?
That's what I'm trying to get at, is,
And so-
how to make that determination.
So there was a case called Krieger versus Public Buildings Commissioner of Newton.
Yeah.
That says, what you're supposed to look at is, quote, the combined effect of all the differences between the use, between the current use and the use which existed at the time of the amendment of the zoning bylaw. You look at the combination, the totality of the circumstances, right? So you
Yeah.
look at where they were operating then, where they're operating now. What were the impacts then? What are the impacts now? The fact that there has been a steady increase in complaints, I think you can conclude from that there's been a steady increase in impacts. The fact that they're moving closer to the residences instead of further from the residences makes a lot of sense why you would have more impacts and more complaints. Those are the sorts of things that I think this board can look at.
Did we ever get an exact count on the complaints and how many complaints we had before the cease and desist letter was issued?
No.
Yeah, why not? We asked for that.
There only has to be one complaint.
just seems to me that for someone who's supposed to be giving us the information to make these decisions from the board, that you would have put a little more into it and showed us a little more information, like how many,
But Rob, we can only get the
It just-
information that
it
we
just
get.
doesn't make sense to
I
me.
know, but we can only use the information that's in front of, you know, that's.
I get it.
Yeah, you know, there's certain things that may be facts that maybe help us more or less, but, I mean, if we don't, we can only make the decision on what we have and what's presented to us, and
It's just frustrating, that's all.
I make a question, please. We're talking 87 and so on. How many homes were on or about the property in 1987? Can you tell me that?
I can suggest that you look at the aerial photos that we provided.
Look, I can't figure out what homes were there. I'd like to know from you, do you know how many homes were there? How many homes in the last 40 years? If there was 10, now there's 20 or 30, all during this period of time. He's grown, yes, but also the residents have grown. You had more people come in here, taking up residence around there. How many were there? You got that information for me? I can't tell it by a picture. Half of them are, they show me behind trees. Real estate people ought to know what that is. Or town population.
all right, so,
So, may I, Mr. Chairman?
yeah,
So if the committee turns to page 14
Yeah.
of the documents I gave you, okay, you can see that there are a few homes. I'm going to go 1, 2, 3, 4, 5, maybe 10.
Where? I mean, these is little things,
The left-hand-
lights
the
on the
left-hand
left-hand side
side.
showing a road.
Right, and there's a number of homes in there.
And what year was this?
That's 95.
All right, so let's say you're gonna give you 10 homes.
Okay, if you go to page 15,
Can we just stop a minute? Of those 10 homes, did you get any complaints from those 10 homes while he was doing what he's doing? How many did you get?
none that I know
That's none. All right, so you want me to go to the next page,
of. The
15?
next page, you can see at the top of the page. the
I see
subdivision-
1, 2, 3, 4, that's, the 95 people were closer, according to my specs, meaning my glasses. And then you got them way up here.
And that's a cutoff part of the subdivision where the majority of the complaints are coming from.
And that's still 1995,
No,
huh?
that's 2001.
Okay,
The subdivision went in 2001, is that
okay.
somewhere in that
Looking
turn of the
at
century?
the Leonard
1998 probably.
Leonard Hill Road.
Lonnet Hill was done in 95. The cul-de-sac at Lonnet Hill was, on the Putnam Farm was done in 95. Dennis Wilbur Drive, which is lower down on there, Putnam Road, was done prior to that. And the houses in
Let Kurt
between were
answer.
pre-exist the opening of
Well,
the
if
sand
we're,
pit.
if we're using this 95 image,
But again, there are
That's
houses
our
that are
evidence.
complaining that
Excuse
were
me.
there in
Excuse me.
1972.
excuse me, sir. If we're using this 95 image as our baseline, obviously, for our, I guess, our facts, there's no development there until '01, because our next picture is '01. Unless we have anything to,
I don't have anything in between those years.
in other words, you got one person saying in '95 it was there, and image that we're supposed to be using.
It was somewhere,
Sorry, Mr. Chairman.
yeah, it was somewhere between 95 and
Yeah.
01, and I know that for a fact.
But it's
Yeah.
incongruous as far as I'm concerned. It doesn't,
If I could, this is the point I was getting at earlier. You can't fault people for moving into new homes in a residential zone, particularly when you look at this 2001 photo and you see how far away any mining operations were at that time from where they were moving into. Now you look at where the operation is, and it's much, much closer to them. And that's exactly what we're talking about. The expansion of the footprint coupled with the increased impacts to those houses that predated that expansion. That's what this board needs to decide. If you decide that's not an increase in impact that constitutes an expansion of the use, that's your job to do. And, you know, Mr. Meskis, just, it wasn't his role. If this board makes that determination, then that's your determination.
So, well, Mr. Meskis, you had said in your statement that you said there was 2 processors on the property right now, or just 1? They put a new one on in 2000.
They're in,
Is there a photo with 2 processors on the property?
yes,
I don't
page
see that.
26,
Yeah.
upper portion of the property towards the Buffinville Reservoir.
Yeah. I see the one on the bottom, but I don't see the
Yes.
one on top.
Up on the top, I probably blew it up.
Is that yeah?
I blew it up, page 28. There's a blow up of that area on the upper portion of page 26.
That thing is there.
Now, is that a crusher, conveyors, conveyors and crushers?
Processing equipment.
So what you're really saying, Kurt, is that it's not so much the degree, the increased degree of use, as so much as the adverse impact from the degree of use that's really the problem. So the fact that they got a new processor or they moved to a different spot isn't necessarily in and of itself the reason for the cease and desist, but the fact that there's a change in the impact to the neighborhood is more the reason for the cease and desist. Is that what you're saying? From what both of you just said to me tonight?
It's everything together. You might not take just the fact that they had a second plant, or just the fact that they increased production, which again, you have to decide who you believe on that issue, or just the fact that they're expanding their footprint. You take everything together and you make a determination. Given all of those things taken together, does it pass that, invisible line, or doesn't it? Those are the sorts of, hard calls that this board has to make, that Mr. Meskis doesn't have the authority to make, only you have the authority to make. And I want to emphasize 2 things. Number one, the burden is on the applicant to convince you that Mr. Meskis was wrong.
Right.
Number 2, if you uphold Mr. Meskis, that's not the end of it.
I know that.
They can still come back, and this board can still work with the applicant, work with neighbors through the special permit process to come up with a reasonable approach. Doesn't mean that they're confined to their historic.
What do you mean by a reasonable approach? Yeah, obviously you worked on these kind of cases
Yeah.
before, so
Well,
what is
I
a reasonable?
can give you some
You
examples.
envision.
Agreed upon limitations on how far they can expand. You know, I think we can all agree it wouldn't be reasonable for them to expand right up to the property and to be blasting on the property. I think, you know, we can probably all agree that some level of expansion is reasonable as long as there are some protections put in place.
Protections
Maybe
like
it's
what?
noise control devices on the crusher. Sound mitigation. Limitations on hours of operation. An agreed upon limitation
Has there
of
been
how far they can
complaints
expand.
on the crusher noise?
I'm sorry?
Has there been complaints on the crusher noise?
Well, I think what.
No, we're limited to the cease and desist. Hey, Bill,
Yes.
so we need to look, if the applicant ceasing,
Well, I was just-
always discern, you know,
Yeah, I was just-
that's a discussion for another day, and I don't wanna be here till midnight.
That's fine.
Yeah, yeah.
Yeah, I just explored it.
Yeah, I don't disagree with you. I mean, if that did come in front of us, then we'd probably wanna find out, you know, to what extent, but
Okay.
we need to figure out this
Stay-
tonight. Let's stay on the,
Stay on the.
does anybody else have anything for Mr. Meskis or his counsel? Any other questions? All right, so we'll hear from Hilton Construction again.
Thank you. Good evening, Mr. Chairman, members of the board. Before I begin, I want to thank you for your time, your patience, and your attention to this very important matter. Important matter on behalf of myself, my family, my employees, their supporters, and the rest of the neighborhood. In closing, I want to address a couple of issues, and I want to address some of the points that were made tonight. The first important issue are the events leading up to the cease and desist letter in 2017. They were important enough for Mr. Meskis to raise again tonight. First of all, in 2016, Mr. Meskis received a written complaint from the abutter. As part of his role as CEO, as you know, he's supposed to do a thorough investigation, research the issues, and respond to the abutter complaint. He did that. He wrote to two of the abutters who had complaints, and he said he had no facts at that time to suggest that Hilker Construction was doing anything to violate the bylaw. He confirmed that in a letter to Jonathan Hilker of Hilker Construction. Now, Mr. McGrath asked Mr. Meskis, well, what changed? What changed between the time you sent those 3 letters and the time you issued the cease and desist almost a year later? His response was this. I looked at Google and I saw a single 1995 ortho image. That's it. That's the entire basis for this cease and desist in front of you tonight. That was his response. In fact, Mr. Howard asked Mr. Meskis, well, how many complaints did you have prior to issuing the cease and desist letters? His response previously, if you recall, was 3. That's it. So think about impact in the neighborhood. 3 complaints in 2016. We've talked at length, or excuse me, the town has talked at length about this expansion. We've looked at a number of photographs together. I want to revisit some of those photographs right now. And what's interesting is that Mr. Meskis' letter, although he's supposed to be impartial and unbiased, he uses the word.
Hold on, we're not gonna, well, let's not go there.
Okay.
All right.
No, but the point I want to make is that
Yeah.
he now relies on information that wasn't part of the cease and desist, as part of his position. But regardless of that, I want to talk about the pictures that he talks about and the impact on the neighborhood. So he talks about this 1995 photograph. You ask him if he had any complaints from 1995. No. He shows you the photograph from 2003, which is page 17, and you see what he considers an expansion at this time.
Yeah.
Were we here in 2003? Did he receive any complaints in 2003 from this expansion? No. What about 2004? 2005? 2007. So now, at least according to Mr. Meskis, they've been in this area since 2001, and he hasn't received any complaints. He hasn't issued a cease and desist or any negative impact on the neighborhood. 2008, 2010. 2015, no complaints. We're here in 2016, he received a complaint that he responded to that said he had no basis to issue any action at that time in violation of the bylaw. I would submit to you that impact, that expansion, and that area of the pit has had no negative impact on the neighborhood. What he didn't do prior to issuing the cease and desist is he didn't speak to Mr. Hilker or his son. He didn't speak to any employees. He didn't do any research to determine what was actually being done in 1987 at the zoning bylaw enactment. He didn't request documents. He didn't even go to the property. Instead, he thought Google would be enough for him. Then he issues the cease and desist letter in June of 2007. Again, he confirms, he acknowledges that Hilke enjoys a grandfathered use as a sand and gravel mining manufacturing processing operation. He issues 2 violations. One, for not obtaining a special permit to work in a floodplain. He doesn't address that tonight because the Hilkes have already acknowledged that they haven't been in the floodplain, and they disagree that it's even a floodplain, for over a decade. It's returned to its vegetative state, and that they have no plans to work in that area in the future. And if they do, they'll seek, any proper application with the Conservation Commission. That brings us to the abutters' concerns. There are 164 abutters. 5 abutters spoke with respect to complaints. 7 abutters provided positive feedback that they haven't had any negative impact on their residents or their effect on the neighborhood. 152 abutters didn't find it necessary to make a comment to this board about the impact on them. So when the town says that all of these complaints have had, we've heard 5 abutters comment. We know from Mr. Meskis, he received 3 complaints in 2016.
But are those 5 abutters don't mean anything?
They absolutely mean something. I don't disagree whatsoever. But we're looking at the overall impact in the neighborhood.
Yep.
And of the 5, they absolutely. And I'll address sort of some of the issues that we heard from the abutters. Some were unrelated to zoning. Some raised the issue about mine safety and health act. We know that doesn't apply. It's a mine safety act. And Mr. Meskis addressed that in one of his letters to the abutters in 2016. The building permit for the garage, this board was astute to acknowledge it doesn't have any impact on the use. We have the building permit if you want to see it.
No. It was in 1998 anyway.
Right. The issues with the Army Corps of Engineers, different issue, different abutter, over a decade ago, has no impact on zoning. Market values. One of the comments from the abutters I wrote down was market value. Just last week, one of the abutters sold their property. The property sold for a $200,000 profit above what they purchased it for in late 1999. It was on the market for $309. It sold for $318. So not only did they get asking, they got above asking. So it hasn't affected market value. I have appraisals from another of the other complainants showing that all of their values have increased over time. With respect to the blasting, Mr. Meskis' cease and desist letter makes no specific finding that the blast levels were any different now than they were in 1987. We know from the folks that testified, you have to give them credibility, the employees, the agents. In fact, we heard from a competitor of Hilke that mentioned that she was in business in 1985 competing with Hilke for Hilke's business, that they processed and manufactured different materials. Hilke's materials are from blasted stone. They're sharper, they're edgy. Hers is more rounded. We heard her testify. She didn't have to come back, come here in front of you. In fact, I'm surprised she did. She's a competitor. We heard from Bobby Emon. He was hired by Hilke to blast at that time. I have additional pictures for this board to show that they were blasting at the time of 1985. And Mr. Meskis says in this letter tonight, well, they're unverified, they're unquoted. This board picked up on that. They asked Dick Andrulevich, well, how do you know that's you? Well, you can tell it's him, right? So you can attest the fact that he was there. He says, well, how do you know that you were there in 1985? He goes, he started his company in that year. Hilke was his first client. He was there to blast. He blasted additional, he blasted at the time. And I'd like to submit a couple of additional photographs that show that this rock wasn't just excavated, it was blasted. And you can see one of the machines setting the dynamite.
We can. All in second?
Second.
All in favor, say aye.
Aye.
We'll just do it at the end because we don't. So good look at the rock.
Ciao.
Chop.
So this is in 1997, 87?
This is around 1985.
85.
And we know that because we see Dick Andrelevich in the photographs. He's there if you want to ask him questions.
Yeah, I asked him before. I'm pretty sure it's-
I mean, I have plenty more photographs showing that this is blasted rock. This isn't stuff they just picked out, scooped out of the ground. So there's no question.
I have a question for you.
Yes.
How can we tell from these topographical photographs, we see from 95 till 2015, an expansion in, I don't know what direction it is, you know, moving closer to A.F. Putnam Road, let me just put it that way, I don't know whether that's north or south. Is that north?
It's north.
It's north. So, is it possible that what we see in those aerial photographs are just removal of overburden versus actual blasting during those time periods? How do I know what the difference is?
In the new areas?
So if Mr. Meskis's contention is more focused on the impact because of the use, that expansion of the use in that area, and that's part of the major reason for the cease and desist, Hilka could have removed the overburden, which would not have impacted the neighborhood really significantly, but blasting would have, or is impacting the neighborhood in a different way. And I think that's part of what what he's trying to tell us is that, so how would we look at those aerial photographs and know one way or the other? Is there a way for us to know that?
I don't think you can tell from the aerial photographs. I mean, I think you can, based on the statements you heard from Hilka and themselves, how they worked in that direction.
Yeah.
Towards the pit.
Yeah.
Towards the pit. I mean, you
I
have.
mean to get you off track.
No. You have statements from a number of people that were not only hired but employed by them that work in those areas that blasted. And the aerial photographs don't really do justice to all of the tree removal, the excavation of soil on top, the overburden. I mean, you heard Mr. Lane talk about, you have, and I'll address the one issue, about digging or staying in one spot. If you stayed in one spot, right, I think somebody said, you blast, you move rock, it doesn't come back. It's not like a farm, right?
Right.
If they stayed in one spot, they'd be digging a hole into the ground. You end up with a
In China.
huge hole, yeah,
Yeah.
looking down. And, I mean, I don't think that's feasible, that's not,
I don't think, and I don't necessarily think that,
That in itself would
Yeah.
expand the use, the type of equipment they would even have to use to do that.
right. So, over time, what they've done is they've continued to clear, I mean, they could have clear cut all those trees all at once, right? And they could have removed all this stuff. It's not good mining.
but even if they had done that, so say when they bought that property in '85, if they clear cut the whole thing down, you're not necessarily gonna mine or you're gonna excavate all of that area all at once. So that's not practical in my mind. It wouldn't make any difference one way or the other.
Sure.
And I don't think, at least in my mind, the fact that they're not able to do that necessarily means that they give up the right to excavate for that use in that area. So, yeah, I don't think that I'm in disagreement with you there.
Right. I mean, other than the testimony, we don't have, I mean, you know, documents that show that we blasted in certain areas. We're not
Right.
required to submit that information to the fire inspector.
Right.
So other than the testimony you've heard, you know, from the people who've been blasting at this property for decades, I mean, that's what we have to go on.
Yeah.
But I would suggest that, I mean, you know, in these areas where, you know, they've emphasized the expansion, I mean, you haven't had any complaints. They've been blasting. You can see that there is.
And there's definitely movement in that direction over time.
Right. And you don't have any further complaints received by the ZEO, any impact in the neighborhood.
I have one other question. Is that what Kurt is showing us on, I don't know if you have a copy of what he's seen.
Yep.
So what's on page 28 there? Is that another processor that's on the property now?
No.
What is that?
They have one permanent process.
Okay, so what is this then on that he zoomed in on?
I don't know. I know at
Can
some
you
point in
answer
time.
it?
What's that?
There's some.
Yeah.
Yeah.
That is a subcontractor that we bring in from time to time. They're there for 2 or 3 weeks at a time.
What is it?
It's a crusher and screens, a couple of screens.
So they remove that?
Yeah, they bring it in, take it out. They make a product that we cannot make with our processing plant.
What kind of product?
It's, so our plant is called wash plant. Everything that comes out of it is washed. What they make is dry. It's not washed. And we have one particular customer that wants unwashed.
So it's a boutique operation.
Pretty much, yeah. So they bring it in, they come in with all their equipment, they take it back out. It's out there now.
What percentage do you think of your product is that unwashed product?
Over the course of a year, maybe 10% or less. Yeah, none of that goes through our crusher. They process it.
Now, with respect to the blast themselves, we heard from Chief Floyd. They obtained the necessary permits. You know, he confirms no violations. I mean, I think the town would agree with that. That there hasn't been a single claim for damages at any point during their operation. He talked about the process that you would have, you know, if there was a claim for damages. He has a complaint form. He's told them to take pictures, submit the complaint form. It's submitted to the state fire marshal's office. They investigate it. Then they would submit it to the insurance company for the blaster, should they find damage. He confirmed last time there's been no damage. In fact, most of what you heard from the abutters was that they were concerned about the what if. What if there is damage? What do we do? And now that we've laid out that process for them, they know exactly what the process is. There is a form. Here are the requirements. This is what you do. There is coverage, plenty of coverage available. They should not be submitting, if they think they have damage, claims to their own homeowner's insurance. They can go to A1 Drilling and Blasting. They have plenty of coverage. So it wasn't that they suffered damage, there was the question of what if. In addition to that, HILPA employs a notification system. And this is significant because before every blast, they notify by phone or email anybody who wants to be notified. Importantly, of the 5 complaining abutters we discussed last time, only 1 was on that list. Now, at 2 meetings now, we've identified the phone numbers. They still haven't signed up to be on that list. However, tonight, I was able to obtain 4 additional numbers to call pre-blast. I mean, our hope would be that everyone would want to sign up to be notified of a blast so they're aware it's coming. And as Mr. Cloutier said, I mean, you know, on average, they blast 6 times a year. This isn't every week, this isn't every month, this is 6 times a year. And that's coming from Chief Cloutier. In addition to those requirements, in addition to complying with all state and federal regulations, the HILP has also employed a seismologist, Rick Roll. He's here again tonight. And he places, I mean, a seismograph on any property. I think he does it for 5 or 6 different properties now, and he records all the readings. He's asked many of the complaining abutters to put a seismograph on their property, and they refuse. It would show them exactly what the readings are, that they are within the federal and state regulations, And not only have they been within the regulations, they're in the bottom 30% of the scale. So they haven't even gotten even close to the allowable scale at the very top. Now, with respect to the use of the property, I mean, there's no dispute that Hilka's been using the property for the same use for 69 years, right? I mean, the amount of employees hasn't drastically changed. I know Mr. Meska said tonight, well, we don't have any documents showing the number of employees. Well, you've heard from the people. I mean, you've heard that they have 7 employees. You heard that, you know, they now have 11. With respect to production, I would submit you haven't heard much from the board about noise or trucks. I mean, the issue with the trucks, the production value doesn't relate to trucks going on the road. These are trucks that are on the property. Trucks that are going from one side of the pit, taking product in, dumping it off to the processing plant, running through. That's where the trucks, I mean, that's the production. And again, they don't have documents to show actual production, but they told you that it hasn't changed much. I mean, you heard from Jonathan who said that they can't do as much as the article suggests. So the tonnage really isn't an issue. I mean, it's not, you haven't heard many complaints, and there's nothing in the cease and desist letter that suggests there was a noise or dust issue. I mean, when you look back at this property and the company as a whole, they've been there for 69 years. There's 3 generations. They've been doing or trying to do everything in their power to be a good neighbor. They still want to do everything in their power to be a good neighbor. At the last meeting, I offered to hand out my card to anyone who wanted it to address concerns they have with me. I handed it out again a couple times tonight to address it. They have a pre-notification list. I mean, they want to work with the neighbors, and they're committed to that. This is a family that doesn't want to be put out of business. I mean, their employees don't want to be put out of business. I mean, as Mr. Silverstein had noted, they've allowed us to continue to blast because they know we do have a grandfather status. They know that we have been blasting for these years, or else they would have shut us down. They haven't. That's pretty important. That's telling. That they've continued to issue blasting permits for us since the cease and desist was put in place. And with that, I just want to turn it over to my colleague, Frank Powell, to address a couple of the lead comments of Mr. Silverstein's other than
Mr. Chairman, members of the board, again, Frank Powell, also on behalf of Hilka Construction, and I echo.
Can I stop you just for a second? Because I want to address.
Yes.
You had said that there weren't any complaints, yet I see in the packet here that we do have a couple complaints. Okay? One dated August 18th of 2015 and one April of 2016. So what you had said that the complaint then goes to the state fire marshal, right?
Yep.
So are we to believe then that the state fire marshal said that there were no damages, even though there were, pictures and whatnot?
That's exactly right. And that's, Chief Cludier said there was no verifiable property damage noted at any time. So they have investigated those complaints.
Okay.
That's what I meant by saying that there's been no damage, because it's not been verified.
Okay, thanks, sorry.
Again, Frank Powell on behalf of Hilka Construction, and Mr. Chairman, members of the board, I echo Attorney Polanski's comments and thank you for your time and patience in allowing all the interested parties an opportunity to fully present their positions and concerns. When we started this proceeding on September 19th, I identified the relevant legal principles that guide the board's determination whether Hilka's use qualifies as a pre-existing protected non-conforming use, or whether the use requires a special permit because it amounts to a change, alteration, or substantial extension of the pre-existing non-conforming use. I think the parties can agree on one thing, and that's that the Powers test is the applicable legal standard that the board should be applying. But to be clear, expansion in and of itself does not constitute an impermissible substantial extension of the permitted non-conforming use. You are allowed to expand. Courts that have interpreted the Powers decision from 1973, more modern decisions have said that They reject the concept that non-conforming uses or structures must remain static. And generally, there must be a dramatic increase in the intensity of these characteristics to rise to the level of a qualitative change or substantial extension that constitutes an impermissible alteration of the non-conforming use. Dramatic increase, that's the word that appellate courts have used in this Commonwealth. Owners are allowed to modernize and expand, and I believe as the chair acknowledged that some expansion is to be expected and it's permissible. Now, town council cited the Krieger case. That's a 1968 case. It's before the powers test was even articulated by the Supreme Judicial Court. But it's still distinguishable from the facts at issue in this case. That case involved an oil business. In that case, the court found that there was actually a new use at the property. It was an oil business that originally was used to provide oil to smaller consumers. The property owner changed the use of the property into a wholesale oil delivery business. So that's right there, that distinguishes the case. But even more so, in the Krieger case, the use increased from 200,000 gallons of oil per month being distributed to 1.4 million gallons per month. 7 times the amount of use. That was a substantial extension in that case. We haven't heard any testimony or suggestion that there has been a 7 times expansion in the amount of production by Hilda Construction. And in that case, it was still a close call. The trial court didn't think there was a substantial extension. And then on appeal, the appellate court, after some deliberation, determined that, yeah, in that case, there was a substantial extension. Still very distinguishable from the facts at issue here. And then I just wanted to touch briefly on a couple of the cases that I believe Mr. Doyle had referenced in his presentation. He cited in his submission to the board and also in his oral presentation the case of Town of Billerica versus Quinn. That's a 1947 case, long before the powers test came into existence. And he cited that case for the proposition that Hilka is, their grandfathered use is confined to the exact areas where the so I think, you know, we've come to some sort of agreement that you're not confined to the exact footprint. But in his discussion of the case and in his submission to the board, he left out some important language from the case that even though it's pre-powers test, it's still relevant for the board to consider. In that case, the Supreme Judicial Court said, it does not necessarily follow from what has been said that an existing use for the operation of a stone quarry, for example, or a sand or gravel business, or even for the removal of loam, which was what it was that issue in the Quinn case, can never be continued by increasing the area of excavation after the passage of a zoning ordinance or bylaw excluding such use from the neighborhood. It is conceivable that a larger area than that previously excavated may have been devoted to the use by actual occupation of the land in a manner that physically appropriated the land to that use. For example, by adding structures, used for storage of waste, or preparation of the ground for that use. We cannot attempt now to lay down a rule applicable to all cases. So even in 1947 pre-powers test, the Supreme Judicial Court was suggesting that a sand and gravel operation would be permitted to increase its excavation activities beyond the existing footprint at the time zoning bylaw was enacted. I'll leave it at that. Thank you for your time.
So in sum, we do respectfully request that the cease and desist letter be overturned once in the
Gentlemen?
I had just one, in 1985 or whatever, how many vehicles that are used to haul this rock around? How many do they have in 1985? Two. And how many do you have today?
3.
That answers my question. Thank you.
So this is where, no. So I don't disagree with you in the sense that I don't think that any of those courts would say that a pre-existing non-conforming use needs to be static to the point where the zoning bylaw went into effect. And I think that all of them would anticipate some sort of expansion, more profit or whatever. I mean, that's the whole reason why most of us are in business. And I don't think that there's necessarily a problem in my mind with the fact that, you know, I was reading the brochure for the VX 250 stone crushing process or whatever it is. You know, that in my mind, you know, an extra truck, that processor is obviously going to be more efficient, more capable than the previous, and I don't think that necessarily lends itself to say that that's a substantial extension of an existing use. But, and I think that you guys are talking about the first 2 prongs of the test, and he's talking about the 3rd prong of the test. And, you know, how do I balance that in making my decision? So I think that it's reasonable to expand, and I think it's reasonable to become more efficient over time. But does that have, you know, an impact on the neighborhood because of that expansion? And is that where, you know, this is going? Is that, you know, at what point is the expansion too great that it's going to be more detrimental to the neighborhood than it is now? So I don't know if you have a comment on that. I mean, maybe I'm just rambling vocally.
Well, I mean, certainly, I mean, and that was a question that some of the abutters have had for the Hills, you know?
Right.
How close are you gonna get to us?
Right.
Right, and I think that, you know, as John articulated, I don't know, if the gentleman's here tonight.
Could be me.
Yeah.
I'm one of them.
Yeah. You know, they don't want to be in their backyard. They don't want them seeing what they're doing versus what they see they're doing. You know?
Right.
So they don't anticipate, I mean, where they are now, they're comfortable being there, you know? They don't want to get any closer. I think John can articulate as he spoke to,
He spoke with me,
I think your
Shane.
name, Shane. You know, because Shane had that concern. That was his question, you know? How much more expansion do you have, you know? And John answered that question. I think you can answer it again.
Well, I was asked by Mr. Woodson, as well as his wife, and their neighbors, Mr. and Mrs. Wright, you know, how close are you gonna come to my property? I don't wanna see an excavator at the wall line. And I said, I mean, you kinda have to look at it from my perspective as well. While I could cut every tree, does it make sense? Do I want you to be able to see in and see everything that's going on our property? As well as, you know, I know you don't want to see what we're doing. So it's always been the plan. I mean, believe it or not, we have talked about things over the years. It's always been a plan to have a significant buffer in place. The buffer works for the neighbors just as it works for us. So.
And again, with your decision, I mean, obviously the decision isn't just, you can confirm, you can overturn, you can modify, right? And in the modification, you know, I haven't spoken to my client, but I mean, you could establish that currently where they are, they haven't significantly impacted their stance. But any additional, you know, encroachment on the neighbors would require, you know, coming and applying for a special permit. Now, I don't know, but, and I'm not saying I would even, you know, that's something that in our position would be, but, you know, as it stands now, I mean, you gotta look at the neighborhood as a whole, right? And the impact on the entire neighborhood, not just a subfield. And so I think that's gonna go into the calculus.
We can see them and smell it. They're very close. I provided you with drawing of how close they are.
Can we take a 5-minute break?
We'll take a 5-minute recess?
Or like 3 minutes?
5's fine. Make a vote to take a recess? All in favor, say aye. Another 5-minute recess. You had your 5-minute recess? You had your 5-minute recess. So there was one, member of the town that had some additional documentation to present. You want to just bring that up?
Yep.
Just explain to the audience what you've given to us and.
Okay. My name is Lori Natale, 62A up Putnam Road, and what I'm
If you give
providing.
them a copy.
Oh.
Hand them out and then.
Okay.
Thanks.
This is a letter that I received from my insurance company telling me that they were no longer.
We need one.
Who does?
I do.
You do, okay. This is from my insurance company telling me that they will no longer be, I won't be able to be, insured after I submitted the plastic complaint form due to cracking of various areas in my house, et cetera. And
Your husband said this
right,
before.
but I didn't have copies for you at the time.
Oh, okay, so
So
you-
I'm just providing you the copies
But you
of
still
the
have insurance now,
documentation.
you said.
Well, after a
Yeah.
long, yes,
Okay.
after a long dealing with them, but yes.
Did you put in a formal, complaint?
I did. I don't have 10 copies of
No,
that, but yes, I did.
You did?
Yes.
All right, now, maybe I just don't know how this works, but, so that would have gone to the state file line, right?
Yes.
It should have. Did you get any feedback from the state fire marshal saying,
I don't understand what it says and everything, but it was in 2013. So I don't hear anything further back than what they're stating as 2015. And this was clearly marked as 2013.
no, I guess what I'm,
I don't
Did
know.
the state, what I think what he's asking is, did the state fire marshal actually come to the house? What did they do?
The only people I know that came to my house were these guys who put a size meter in the front of my house, not in the back of my house. Nobody else came to my house.
So what, you filed this, the front part of this complaint, and then where did all the rest of this come from?
I don't know if it was from Hilkers who went and obtained the documentation, I don't know. What I have is right there. Somebody from them.
but is that state fire marshal or?
I don't-
That's from Charlton.
That's
Yeah.
Yeah.
Nobody from the state came to my house other than the people from Hilker putting out a size meter.
Okay.
Now, I can make you copies of that.
No, that's all right. I just was curious.
Okay.
So, all right, so I guess I'm a little confused. I would have thought that there would have been something that would have come back from the state fire marshal saying yay or nay. Well, we've investigated this.
I don't know what she shared.
Well, I know you did. She showed me actually this
Yeah.
this form.
And I don't know if it was given to you,
Well, it was given to it was signed by the Charlton Fire Department that no, there was no damage, I guess, that's what it said on there, or wasn't it a result of the blasting? I just thought that, okay, this thing's gonna go immediately to the state fire marshal, or whatever.
That's the process. I mean, as Chief Woody mentioned, when they get the plan, they send it up, they get the inspection, and they review the information and provide a result.
Okay. Go ahead.
I was the 2015, August 2015 complaint that you have
Yeah.
from last time. And I'm the one who said, so yes, I did file the complaint. It was the first complaint I filed. Was not aware that that was what the process was. When I bought my house, I was not aware that there was a quarry on the other side of the hill from me. And the fire marshal did come out and inspect, and the,
State fire marshal?
I believe, no, not the state fire marshal, I believe just our local, which was fine. The concern that I was, and there was damage, and I told you it cost me close to $1,000 that I paid for it to have the damage repaired. So I guess the question that I have is the same question that the fire marshal had, which was with one. My house has been standing, it was built by Mr. Burlingame, and brand foundation that was put in 1997. So from 1997 until when I had my first complaint, my only complaint in 2015, the blasting and the damages that were happening over all of that time is going to, I had literally a crack, as I told you, that I could see daylight, and that I had water coming in. And I never had water coming into my basement prior. So I can't say definitively it was one blast that caused that one damage, but it was, my house has been standing on a brand new foundation that Mr. Burlingame, a well-respected member of our community, put my house on top of. So you can't really, it wasn't like somebody, somebody hit the house with a baseball bat and there was damage. But after that complaint, which was a pretty sizable movement in my area, and again, that's 2015.
Sure. Now, last week, I spoke out of order, and I was told that this insurance complaint, or whatever, is not in our privy here. It is not for us to make a decision on what you're going through. And I also told Mrs. Natale that I had enough experience in the insurance, and this belongs with the insurance commissioner of the state of Massachusetts. That's where you should have gone. This is an insurance matter. An insurance company has canceled your insurance. And the letter says right in here, not to the insurance, says, oh, Metropolitan will talk to you, but from their underwriting department. That's bogus. You'll get the same answer. But you've got to go to the insurance. It doesn't belong in zoning, period. And you told me that last week when I started telling her how much insurance knowledge I have.
Yeah.
But this goes to, if you're gonna say
This
that
has
my
nothing
house-
to do with zoning,
But if you're gonna
ma'am.
say my house is appraised for double or 10 or 20%, if I can't sell it, what good is
I
it?
said you need to go
Well,
to
that's
the-
fine, but I'm telling you that I will not be insured based on what
Yeah,
I
that's
told them.
The only point I,
That's a
I want to
problem.
look
That's
at
not
it
for us
is,
to make a decision on.
Can I ask a question?
yes.
Doesn't though that, however, represent how the business's expansion is impacting the neighbors? It's again,
Well,
it may
that's-
not be, it may not.
That's why I allowed it to come in.
Yeah.
Okay? Is that, it'll be up to us to decide whether or not there's an impact, whether the increase in, an increase in a substantial expansion or not.
Will make a difference if you guys take a field trip when they're doing the blasting and stay on that area and be on one of those houses?
I don't think it would make any difference at all, because it's not gonna necessarily change the use.
Yeah, well,
They've been
is
doing
there-
that since whenever, so I don't necessarily think,
Is the
is there any more,
that
we have any more
town don't
comments?
really care about, you know?
Any more?
Mr. Chair, just
Yeah.
if I may, the third prong of the power assessment we've been talking about.
Yes,
Whether the current use is different in kind and its effect on the neighborhood.
yes.
I think you have to take into consideration where these residences are. Were they built after 1987? Are they close to the property? I think some of
So-
them might be, and I think that's something that the board also has to consider when applying this third prong. Its effect on the neighborhood might not be different at all. It's just now there's a home right next to the end of the property line.
They don't blast the same way they blast
So,
today.
but this was my thinking on that, though, is that their home may or may not have existed when zoning went into effect. It does exist now. But as the pit expands through its natural life, now it's gonna be coming in closer proximity to maybe some of those homes that wasn't, and maybe that's part of the reason why we haven't had any complaints. And is that impact going to increase? Is it gonna stay the same? Yeah, so has it increased? Has the impact increased? Is it negatively increased? I don't necessarily think the nature of the blast has changed.
But it does change.
I don't think that, and I don't really know whether that does change or not to where you're blasting, and that might be the case. Ma'am?
Okay, we've got these three houses right in our area, Ellis's, Stone's, and mine, built in the 1960s. And it's definitely impacting our house now.
What road are you on, ma'am?
87 A.F. Putnam Road.
Okay, so if they were closer to Potter Village in 1987, and now they're closer to A.F. Putnam Road.
Exactly.
Okay.
But what he's saying is, it's not impacting the houses that weren't there. Well, it's impacting the houses now that were there.
I don't think he's saying that. I think he's saying is that the impact hasn't changed, it's just now it's in a different spot.
Well, it's impacting houses that were there in the 60s.
You feel the vibration then?
No, that's what I'm saying.
All right, so there's no
That's
more.
the problem. We don't hear nothing.
I think what we should do at this point is that, unless someone else on the board has anything, in my mind, I think I've got enough factual information in order to deliberate.
And make a motion that we close the hearing and.
The open portion of the hearing.
Yes, and we'll start to deliberate.
Second.
All in favor, say aye.
Aye.
All right, motion carries. All right, so at this point, we're gonna discuss how we're gonna vote, what we're gonna vote, and we're not gonna take any more testimony from anybody in the audience at all from this point forward, unless we specifically ask a question that we want someone answered. So you may agree or you may disagree with what someone on the board is saying. I appreciate you kindly refrain. It's just a part of deliberation. Unfortunately, not everyone in the room is gonna get the result that they want, and, there's nothing really we can do about that. But we will deliberate and go forward from there. So I do appreciate your patience, appreciate kindly refraining if you don't necessarily agree with what someone on the board is saying. All right. So gentlemen, I think we got two parts in front of us here. One is, what we really haven't discussed all that much in the cease and desist letter is the easier part in my mind is the cease and desist from expansion into a wetland area without a special permit. So I think that
Is it floodplain or wetland?
floodplain, I'm sorry, not wetland. My bad. Okay. So, yes, Hilka kind of acknowledged that they're not in that anymore, that they've let whatever the vegetation grow. In my mind, I think that should stand. If they're gonna go back, if they've used it in the past, and they're gonna go use it in the future, they should, yeah,
Is that the, this area?
yeah, that side area there, I'm trying to find the pictures.
I think that's strongly monitored by the
Right, but according to the bylaw, is if they wanted to, we had, if they wanted to work in that flood. Is it, no, that's not the one. That they need a special permit.
But from what I understand, they're not trying to do that.
Yeah, so see the floodplain, I can't find this, no, we have. Yeah, so this is, so see the floodplain right here? So part of what Kurt's, in his cease and desist letter, he had said that that violates the zoning bylaw, and if they were gonna operate within that floodplain, that they needed to get a special permit from us.
And from what I understand,
No, I don't think they're saying they're not operating in there, but I think
choose
that's.
to believe that.
I do too, but I don't think, I mean, if they have in the past, and there's a potential, they may.
But I'm saying that the Army Corps of Engineers is posting monitoring that too.
That's not, I have no control, we have no control over the Army
Well,
Corps
that's-
of Engineers.
Right, but you're saying
I
in the
think it
future,
should-
in the future, something.
So I say,
could
what I
happen.
think is that part of the, I don't think that, like, on other cases that we've had, this isn't an all or nothing proposition necessarily, all right? Is that we as a board, because Kurt had two things. One is this part, and the other part is whether or not there's a substantial extension that they require a special permit for, right? And so, my opinion is this, is in terms of the floodplain, I think that the cease and desist order should be upheld in terms of the floodplain. That if Hilka wants to go back into the floodplain in any way, they should apply for a special permit in order to do so.
Yeah.
That's all. In terms of the other part of it, the other part is that, is there a substantial extension?
Putting that in our language as a motion, is that what you're saying?
Yeah, so I think, I'm just saying when we should vote, right? When we make a vote, I think that we should vote at least more than one part, all right? I don't think that, because we might decide that we don't think that it's a substantial extension on the property, but in terms of the floodplain, that I think the cease and desist order should stand. Okay,
So what are we defining as the floodplain?
whatever,
Is this what you're looking for?
no, it was the one that Kurt was originally
I don't see it.
submitted.
Because
I was
this
looking at it.
is what is originally submitted. isn't
That's what he
it?
originally submitted? Yeah, so there's a map on there that, and part of his cease and desist order said that it looks like that you've expanded into the floodplain, and that the bylaw requires that you get a special permit to operate within that floodplain. That's separate from the Army Corps of Engineers, that's a whole nother ball. That's something they need to do.
And that's what we want to include in our motion. Is that
Well,
what
that's what I'm saying.
Yeah.
All right, so let's get, I wanted to get that part out of it.
You're saying about the special permit. When he went into that so-called thing.
So they went into-
He did not get a special permit.
Correct.
And he thought, in my opinion, he thought that he didn't have to because he was grandfathered in. Is
And-
that the whole, that's the
No,
crux
yeah,
of that?
we're gonna talk amongst ourselves now.
Well, I know that.
Yeah.
I know that. I can look into the audience.
All right.
But
Yeah.
like, that's going on that.
So what I'm saying
okay?
is that Kurt issued the cease and desist order on that, and I think that should
As
stand.
a result of these complaints, is that right?
Right.
Oh, he found an additional situation other than?
Then just the other part is that whether or not he's expanded
Right.
his operation
Correct.
to beyond what's allowed under the zoning bylaw.
So the fact of his ignorance, if I may, and I apologize, that he didn't know the law to do
Right,
it.
whatever the reason. right.
Whatever the reason,
Right.
okay.
And in the future, if the cease and desist stands, and they
Yeah.
don't appeal, and if they
He
want.
can appeal.
He can still appeal.
Okay,
And if he
that's
wants, and if they want to operate, if they don't appeal on that part of
They
it,
can get a special.
they can
permit.
come to the zoning board of appeals, whoever's there at
We'll
the
look at
time.
that at
And they
another
can
time.
issue a special permit. That's all I'm
Okay.
saying, just on that one part of it. The other
Okay.
part, I think, is really what we've been talking about. We really haven't touched on that all that much.
No, we
And I
haven't.
think part of the reason why we really haven't touched on that is because Hilka said themselves is that they're not in that area anymore. They let it return to a vegetative state, and there's no plan to do it. So I don't think there's any harm or foul by saying it's, yeah, I think it's a, they're not,
It's a non sequitur.
yes.
Excuse my lap.
So the other part of it now is did they violate,
Well, why don't we, if I may say so, Mr. Chairman,
yeah.
why don't we vote on just this now, and then we'll go?
No, we should
You
do it
wanna
all-
talk about the
let's-
whole
let's-
shebang?
Let's just do
Okay.
one, yeah. I don't
All
wanna,
right.
I don't wanna break that part up. I don't think
Okay.
that's a good idea.
All right, fine, you're the boss.
So now is the other part. The other part is have they violated the bylaw, expanding their grandfathered use above what the bylaw and the statute allows?
For me, they haven't. At least the two prongs of that powers test, you're talking 40 years, 2 trucks to 3 trucks, 4 guys to 7. And you look through the testimonies, they've done, and if you look at it, they're, what they are now, is quite a modest expansion, as far as I can see. So, I don't see, at least the 2 prongs of that powers test that they were talking about.
Yeah, you know, and I definitely see that, you know, and I look at the first 2 prongs, and this is where my, you know, dilemma is. When you look at the first 2 prongs, and you kind of look at it, right? You know, over the course of 40 years, you know, Kurt gave us that brochure. And the brochure talks about how, you know, they bought this new stone crushing processor, how great it is, and, you know, it crushes all kinds of rock and changes diapers and does all kinds of great stuff. And, but, you know, the old one could be 30 years old. I mean, and, you know, if I have a 1979 Olds and I'm gonna buy a newer car today, it's gonna have more bells and whistles and be more efficient, whatever. So I don't necessarily think that the fact that they bought one more truck, or they upgraded, or they upgraded their processor necessarily constitutes that expansion. I don't even necessarily think that, you know, and this is, so, you know, even if they went from, you know, 500 tons a year to 2,500 tons a year, I don't know if that's considered substantial expansion either. You know, I looked at some of the maps. So what I did was, I was looking at some of these maps, right? I looked at this map right here. This is, I think, the 1985 map. So if you look at the map, yeah. If you look at the map, that map, and you look at like, so I was looking at this. So that right there is pretty much the edge. When you look at 2001, that's the edge.
Yeah, see, this is what I said, it's a modest expansion.
Yeah. So they're, I mean, I think that they've expanded their use. I think that it's not an unreasonable expectation that they expanded their use, all right? But now, and I think that you're right, out of those first 2 prongs, I'm not sure that it's to a degree that it's beyond what would be considered a substantial expansion to consider it. But now when you look at the fact that the use has an effect on the neighborhood.
Oh, wait a minute,
Yeah.
what about this map right here?
Yeah, it's there's the thing there, and they've expanded, yeah,
2016.
yeah,
Okay.
yeah, so they have expanded from this point up north.
Yeah.
Yeah, I'm not disagreeing with that.
Okay.
Yeah, yeah. But I mean, you look at, when I started looking at it, you look at this map, and it looks like, oh, that's not really that much, and when you look at that map, it looks a lot different. But when you look at the, yeah,
if you look
it's
at this
not,
map and
you're
it
really
was
looking at
19
this part, and
yeah,
maybe a little bit over
1995,
here.
yeah, it's gonna be-
Yeah, so it's not it is an expansion, it's not more than double at this point.
No,
It's
but it
less.
is an expansion.
It is an expansion.
What's the you good,
My thing is, both the properties were purchased before '85.
Yeah.
Who would say that wasn't their intended use?
And I
for
think
them?
it was. I don't think there's any kind of, yeah, I don't disagree with that, yeah.
I think with this type of business, that moderate expansion is gonna be necessary. And then once they use up that property, they're done. There's not gonna be any more rock that they're gonna be able to blast and take out of there at a certain point.
They'll do
You know,
some
unless, like they're
rotating.
saying, if they go down, and that's a whole nother bag of apples, I feel. That'll be a different.
No.
So, you were gonna say something about the last?
Yeah, well,
Third column.
is the
Third column.
use and its kind, is it having an effect on the neighborhood? And this is the thing, I think this is where part of the problem is that, maybe in 1995 or 2001, maybe they're blasting over here. All right, now maybe they're blasting over here now, and then all the people on AF Putnam Road up here, and Leonard Hill is right here. All right, so the people that were over here, there's no issues, but since now it's moved, no, I'm not saying that. Yeah, I haven't made up, I don't know what I want, all right? So, I don't know if you guys have made a decision on which way you want to vote.
I have.
You wanna make a provision somehow?
I don't know if we can.
Yeah.
I don't think you can either. See, it's pretty cut and dry.
So if we say the use is the expansion, so if we uphold the zoning enforcement officer's decision, then the cease and desist order would stand. And the only way that they could expand is if they either appealed this to a higher court, which overturned it, or they applied for a special permit, which it would come back before us to decide whether or not we should grant them a special permit.
Or you can't make provisions on that.
I don't know the answer off the top of my head. We'd have to find that out. I mean, if that's the way you guys want to go, though.
Well, it's probably for you guys.
I mean, the thing is this, all right, so
But if you-
if,
if you have a will to-
so in order to overturn the zoning enforcement officer's decision, 4 out of the 5 of us would have to vote to overturn. Eric will aware of this provision. So, well, it wasn't my fault. So, I mean, are the 4 of you guys looking to overturn?
Well, I am.
I am.
I haven't made up my mind.
It's fine. Respect your decisions.
How long do you want to deliberate?
You feel that
What?
there-
How long do you want to deliberate?
No.
I don't know.
So you feel that
I don't want to
there's
be
been
here all night.
no effect to the neighbors? That's basically what you're saying, is that there's been, for the third prong, you're saying that there's been,
Well, it's,
how many residents and abutters are there?
Mhm.
And how many complaints have there been in 68 years or so?
Yeah, I mean, as far as we
7 out of
know-
164.
Seven.
Right.
And that,
Seven
those
in
two
10
were,
years, or
Yeah.
seven in 40
Right.
years, is that,
give you a
is that a
5.
change, or is that?
Well, you know, the other thing too is, you know, Hilka's counsel is essentially saying that the impact has been the same this whole time, it's just not necessarily in the same place. So has the impact changed? So when they vote, you know, when they were blasting closer to Potter Village Road, where they you know, the blast could have been, the blasts were there, then when now they're closer to Learned Hill Road and the A.F. Putnam Road, it could be the same blast, but it's felt differently, yeah, because it's closer.
And then when they move away from it or go somewhere else?
They could get closer even still.
Well, you said you was gonna have a barrier.
Right, but don't forget this, and not to say that, you know, this has been a family business for 3 generations, and I'm not saying that's gonna change. But we don't necessarily know what the future's gonna hold. I mean, you know, there could be a rock crushing company from, you know, Omaha, Nebraska that offers them, you know, $15 million for the land, and, you know, everyone's off to Boca Raton for, you know, and that's, and once we make our vote, that stays with the land, it's not with the owner.
And we can't predict the future one way or another, so
No.
I see how
No,
that's
what-
relevant.
what it is.
Oh, it is relevant. I
Because
think
it runs
is
with the
relevant.
land.
I think it is relevant.
And if I got offered that kind of money, I'd,
Yeah, well, you can't look into a crystal ball.
right, and then those guys, and then someone comes in and spends all this money, and then they excavate right to the property lines, and we've already voted to say, hey, you know, it's,
We have
you
to
know, it's-
vote on what's now, not what's in the future. Come on.
That's the way I think.
That can
I
happen with
understand what you're
anybody,
saying, but
anytime.
that's the thing with us, is that
Playing out
it
left
also,
field almost.
it's not with the owner, it's with the land. That's what we're looking at, is the land.
So again, if that's
It's not gonna
question, we don't think that there's been any appreciable change.
That's the point.
Yeah, the last few years.
That's a given.
I think it would have to be a drastic effect, or even a moderate effect to the neighborhood. And I don't even see a moderate effect. I mean, I could see if we had
You know, that's
20 complaint letters here in front of us, out of 130 abutters, that would be, you know, might even be a different story. We don't even
There
have
isn't.
that.
But there isn't.
So where do you go from here?
I don't know. I mean, you guys don't think that the effect on that third prong is substantial enough to say that it has, that there's been that kind of expansion that violates the bylaw?
I don't think so.
I don't think so.
I don't think so either, but I'm not projecting into the future, that's why I'd like to have
Yeah, I don't,
provisions.
yeah, I don't. See, if this was a special permit, it wouldn't be a problem at all, because we could talk with them and put conditions and things like that.
No, that's the way it is.
Barry, what do you think? I mean, do you think that,
I have one.
what time is it?
Almost none. What do I think? I think we can't, personally, I mean, I can sympathize with the abutters, the few that there are. If you put yourself into that situation, if you've had a, you know, you've had property there since the 1800s or whatever, and now, you know, now you're being affected by something that you weren't affected before, how would you feel? Okay, so, I mean, that's the first thing that comes to my mind, is that, yes, you know, you can argue the point that, well, they really haven't expanded, or the intensity, because of the number of blastings per year or whatnot, really hasn't increased. But then again, you know, as Frank's saying, as things get closer to the communities that are up in the northern part of the area, if there's gonna be more houses built up in that area, which I was under the impression there would be, there's gonna be more people that are gonna be affected. So, I mean, you just can't, I personally just can't throw that away as a not to consider. But that's just me. You asked me how I thought.
Yeah, and I think, you know, that's the thing is that, right, so we have, they're in effect now, okay? If you vote to overturn the zoning enforcement officer's cease and desist order, then, so we're essentially saying that the effect is not substantial enough at this point to say that it's, if they expand further, so there's no hold on us on what that expansion is after that point. So there's no, it's not that I think.
You can issue another cease and desist order, things get worse, is that what you're saying? Down the line?
Yeah, I mean, we're right back here, you know, where's the threshold, you know, where is that point where you've expanded that it's having that effect? Bob?
Is there any real estate signs for these people to come in? Is there land for sale around it again, right now?
I have no idea.
Well, that's another thing, another situation, and there isn't. I mean, I don't know that, but I would say there isn't.
It's still kind of looking
Right,
at the
well, so
crystal
then-
ball again.
Yeah, and that's the thing is that, and you know what, and the thing is
Yeah,
that
we
I don't
gotta
really
focus
want,
on-
I don't, it's not like that, like, I wanted, you know, have Kurt or us to have to revisit this,
2 years down the road.
right, you know,
Well, if that's a possibility, then fine. We may not, either one of us, be here 3 years from now on this zoning board. New
they'll be
people.
like, what was this zoning board thinking?
Well, that's up to them to say what I was thinking. I voted, right? I don't know what I'm thinking.
Were you thinking this before tonight?
Hmm?
Yes.
I definitely looked at the green, and I thought, I had thought mostly about that. And I don't think the degree is, you know, with the new equipment or whatever, you know, even that expansion part, you know, it's not like they just like clear cut the whole acreage or whatever.
I know.
All day. Well, let me ask you this then, right? If we're allowed to modify the order in some way,
Would Barry be comfortable with it?
would you guys be comfortable?
Yeah.
You guys be comfortable.
I'm comfortable with it.
I think we should be looking at what's at hand and not what could be or what is a thought in, you know, in someone's mind on what could happen to the neighborhood and growth-wise, or in the future. That gotta be dealt with at that time, not now. And I think our decision needs to be made on the information that was given to us today and the prior dates. And honestly, the information that came from the zoning enforcement officer, I think there was more information given from people and not him, which I feel is, you know, that's a whole nother issue. But I think we need to focus on what's here and what's now, and not what could be.
Yeah, we don't have a crystal ball as to what could be. I just
Can't do that.
I just feel a little more comfortable to listen to. But I will vote for the overturn of the appeal if somebody wants to make a motion.
Well, let me put it, if you're gonna force me to vote right now, I don't know how I haven't made up that part of the decision yet.
We're not forcing you into anything. You've already asked us pretty much, I told you what I thought, he's told you what you thought, and so has the next gentleman. So there's three of us. You already know. Did the framers, could they know what the hell how the world is now? How the United States is? Did they make decisions on what's here in 2017? Huh? I don't think so.
Oh, they did.
All you're doing is you're interpreting, supposedly, in this great country of ours, what they're supposed to interpret it, but they don't. They do what their own feeling is, and it's not right.
I'm not trying to do what my own feeling is.
I'm not saying feeling, I'm saying what the feeling is in this country.
No, I agree with that. I don't disagree with that.
So you've got a law, and we have a
Well, we have a
We have
gray
a-
area,
we
we have
have
a
a-
gray area, you guys haven't made your mind up already, that's all.
well, listen, been here a long time. That's why you have the
Who,
chairman.
me?
That's why you
Yes,
have,
because he knows.
that's why you are the chairman.
Yeah, that's great.
Well, hey.
If we only look at what's right here, right now.
Yeah. Why is it, why hasn't that been put to bed?
You know, gentlemen, what I'd like is, and if you're all right with it, is I'd like to find out whether or not that if we can only do an up and down vote on this.
Well, how do we find that out?
I guess we can ask the attorneys that are here tonight to see, or otherwise we're gonna have to ask, you know, town council to see what options that there are on this. Let's do that just to be on the safe side. All in favor, say aye. Aye. Bob?
So you're gonna go to town council for,
We'll ask these gentlemen tonight, okay?
what gentleman? That gentleman there?
Yeah, special town council and council for Hilka.
Yeah, put it up to them then.
Well, I'm not putting it up to them, I'm saying, it's up to us.
on their council. Is that what you're saying?
He was talking about whether we're able to make a cut and dry decision out there.
So
Well, I thought we were. I thought that's what we're here for.
is that our only option? That's what I'm asking.
Okay, if you want to ask them, fine. I'll say yes.
Counselor, want to get, so if we wanted to make an other than up and down decision on this portion of it, is that permissible?
So, I'm happy to jump in first.
Yeah.
Under chapter 48, section 8, this board steps into the shoes of the zoning enforcement officer. So you have the same authority that he would have had to issue any orders he would have had with respect to the use of the property. That, I don't think that does include putting conditions on your order, but you could modify the order. So, I don't know if this is where you're going, but if your thought was, well, I'm okay with what the current footprint is, but I wouldn't want to see them expand anymore, then you could modify the order and uphold it, and the modified order would be you can't go beyond the current footprint. I will say it's, the case law is not totally clear on this. There was one appeals court case, I don't remember the name of it, where a ZBA said, okay, this pre-existing non-conforming trucking company has increased the number of trucks to whatever it is now, but we're not gonna get more trucks on there. And the appeals court said that would be on the authority of the ZBA. So, I don't think it's totally clear. Now, if there were a situation where the applicant agreed to that sort of condition and didn't appeal, then obviously any unappealed condition is enforceable once that 20 days goes by. I haven't heard that sort of agreement coming from the applicant. So I don't think the case law is just not very definitive on this, but the statute gives you the same authority that the zoning enforcement officer would have had, which would include to issue a different order, but he doesn't have the ability to put conditions on his orders.
Do you have any opinion, Counselor?
Yeah, so my review of the case law, I would agree that you can modify the order. You can't condition the order as this facility is located, but you could modify it to say, where they're currently located is the footprint, or where they've gone in 2003 is the footprint. You can modify the order, but you can't condition it. I would agree with that.
Are you asking for more litigation and getting out of it that way? Is that what you're doing?
More litigation. We're the only ones that make money on litigation.
Well, I just think you're opening up, but what you're doing, the way I see it is, you're you're getting out of it by what you're trying to do, but I don't see the point of it. You're either all in or you're all out.
You're in for a hole.
I'm.
Yeah, I appreciate that from you guys.
That's
Well,
okay. That's okay.
That's fine. I can't be three, it's truly rare. Then it's a pallet. Push you over the side. Look, I need to think about this.
So what do you wanna do? You gonna think about it till next week?
Yeah, you know, on the one hand, yeah, I think that it's not completely unreasonable, their expansion, but on the other hand, you know, there's definitely effect in the neighborhood. I don't know, you know, which weighs more than what. If there's a possibility that we could modify the order in some way without it being a condition, then possibly, you know, that might be, but I need to.
I think that's opening a whole nother can of worms for us. I think we need to just go
Regardless, no matter what happens though, we're gonna,
ahead now. I wanna deliberate and wait for another day.
all right, so, I'm gonna put it this way, okay? If we vote right now as it stands, and I vote to uphold the order right now, okay? Then the order is upheld. Then tomorrow, Hilka can file for a special permit, and we're talking about this thing, right, a month from now, the same exact conversation. So, my goal is not to open up a can of worms, is to, you know, vote the way I think that I should vote, and I'm not ready to do that right now.
No, that's understandable, but
Yeah.
I'm saying going
May-
ahead
you know,
and
maybe-
putting things
Maybe,
onto the order.
maybe next week, maybe I've had, you know, I look at it a little bit differently, and
Yeah,
change my
I mean,
mind one
I
way or
have
the
no
other.
issue with taking the time for you to think it over and things like that.
So, here's the thing is, next week, we already have a meeting next week, Bob. We have 3 of them?
Three?
Yes.
So that's a full one, so it can't be next
Well, that's right.
No, we have to do it.
We have to do it.
We have to do it.
We got till November.
We only get till November 3rd. Yeah.
It's your call, Frank.
Yeah, I just, I haven't.
Yeah, I mean, that's reasonable.
Yeah.
I'll make a motion to continue the meeting.
I haven't. I suspect it is.
Our meeting is already scheduled upstairs.
We can't make a switch.
No, well, I think we have to open the meeting upstairs.
Open the meeting and adjourn down here.
Can you do all 3 upstairs and then come down here?
Yeah, that's what
Adjourn it down here.
So we'd have to have 2 separate meetings.
Those are new meetings, there's a new item.
Right, we can't change where those meetings are once we advertise where they are. The only way we can do that is that we open the meeting upstairs and then adjourn it and then come back and then move to the new location and open the meeting that way. It's the only way we can do that. So, my feeling is that next week, I'll have an answer one way or the other, all right? This is not gonna be like we're gonna sit around looking at each other. Yeah, so, I need to think about it, I need to see and then this is gonna be straightforward or whatever. I'm sorry to have to do this to you gentlemen. I just haven't. I've listened to everything, you guys have brought me more stuff to think about tonight that I really hadn't thought about, and I'd like to mull it over a little bit longer, unfortunately. Not that I haven't spent a little bit of time thinking about this. So, if we do vote next week, like I said, what I'll do is that we'll have our normal meeting. We have 3 applications for variances. Those will be upstairs in our normal room. And then we'll probably just, have a recess, come down here to continue it down here. All it's gonna be is a vote. That's all we're gonna end up doing. Won't be a lot of discussion or anything like that. These guys have already made up their mind. It's just, I'm the only person that hasn't, I guess, so. I would probably say, probably 8:15 at least, that we wouldn't do this, all right? So,
What day was talking?
24th, is that?
24th, we have a meeting anyways on the 24th, yeah. We haven't reserved the room for the 24th, this room for the 24th, so there's a possibility that we may not have, the room may not be available. If it's not, then the recording secretary will post something outside. We can't put it on the website, can they? Yeah, how quickly do they change that website? Yeah, so we'll try to put it on the website, we'll post it outside the door as well if it's not gonna be in this room. Right, just leave that way. Continuation yes. All right, a motion to adjourn until next week. All in favor, say aye. Aye.